versus public policy is a topic which the lawyers and the professionals who intend to practice on the arbitration side is one of the issues which keeps bothering the individual, whether it is from the person who is getting the contract executed or person who enters into a contract. But whether such exclusion clauses have any legal validity or what is the way ahead. And in terms of the Contract Act, Section 55 plays a pivotal role. And what is the party autonomy who's entering into that? And what is the public policy? Public policy is a debate which normally, as in the arbitration proceedings, in terms of Section 34, we keep on discussing. And there are a lot of webinars and topics to be discussed on the arbitration as well as the contract. But we felt that this is a particular gray area, or we can say that where there's not much of insights available. Consequently, we requested Mr. Arvind Kamath, the senior advocate, who has immense knowledge on the arbitration side, and consequently, where the Arbitration Act coupled with the Contract Act, as to how their interpretations have to go across. And as such, we thought on a leisure day, that is the weekend, to have the insights on a subject of arbitration, and that too more specific, that is the party autonomy versus the public policy. Without taking much time, though, I can share shortly that he has more than 27 years of practice, and his firm is not only recognized in Karnataka, but across as well, because once you enter into arbitration, and especially with the MNCs, they say the vision and your thought process is also changes from 2-dimensional to 3-dimensional. And without taking much time, I would request Mr. Arvind Kamath to straight away take the baton and take the things forward.
Thanks, Vikas. It's an absolute delight to be on Beyond Law. In fact, after I first came to know about Beyond Law, I happened to visit your website. And on your website, I noticed two very thought-provoking quotes. One by D. Rabba, who said that gaining knowledge is totally in vain if you do not impart it. And the other one is a very well-known quote by Gautam Buddha, who said, "There is no wealth like knowledge, and there is no poverty like ignorance." Good to know that you are guided by such eminent thoughts, and in that ethos, you have set up such an incredible platform for the dissemination of knowledge by those who have gained experience in their respective field. Thanks for considering that I have gained some knowledge which I could share. My personal motto of life is to gain knowledge and share it as much as possible. That is something which gives me immense joy. And considering that you have conducted nearly about 200 webinars on the platform of Beyond Law, it's a double delight to be here and sharing my thoughts. Contract law is obviously one of the most fascinating subjects in law. And I have noticed that there have been a couple of webinars on Beyond Law on this particular subject. But the issue that I am going to deal with today is about the contractual exclusion of damages. And then we will try to find the balance between the party autonomy and the public policy. And I must point out that my focus would be on, with particular respect to the infrastructure projects, because that is where the law has developed, and with special reference to the Arbitration Act. The exclusion clauses are mostly found in large infrastructure projects, contracts of infrastructure projects. And in all of these, essentially, there would be arbitration clause. So we find the development in the sphere of arbitration in respect of these disputes. So therefore, I would be focusing on the infrastructure projects. But nevertheless, prior to that, I will make an attempt to capture the concept of the unconscionable bargains, the law relating to that which developed in England. So since this topic deals with the exclusion of damages. Let us begin by understanding the concept of damages. Now, what is damage? Damage is a monetary compensation which is paid when a party suffers due to a breach of contract. So therefore, the necessary ingredients for claim of damages would be that there has to be a contract, there have to be parties to the contract, and both parties should have had some obligations to perform. And one of the parties should have failed to perform the obligations, and the other party should have suffered a loss owing to such non-performance, and there should be a causal link between the two, which is when he can claim damages. There are two circumstances under which damages can be claimed. One is the statutory, and all of us know that Section 73 of the Contract Act deals with that. And if one party to a contract is able to satisfy all the ingredients which I just placed before you, then he can claim damages under Section 73. The other one is where parties by contract can agree that a pre-agreed sum is payable whenever there is a breach of contract, which is popularly called as the liquidated damages. Now, if the parties pre-agree that a certain amount is payable in the event that there is a breach, that agreed sum is payable regardless of any proof of loss that the party has actually suffered. But then that law has been substantially watered down by the Supreme Court of India by opining that if the pre-agreed sum is a reasonable sum, then alone the court can allow it. If it is not reasonable, then the court would insist on producing evidence of the loss suffered. So with that, we come to the crux of the issue today. That is the question that is placed before us for the today's presentation is that, can two parties to an agreement agree that in the event of a breach, or if there is non-performance, no damages is payable? So can they agree that under whatever circumstances, regardless of what is the non-performance, can they agree that there is no damage which is payable? Or whether such exclusion clauses would militate against Section 73, under which, if at all there is a breach, a party suffering breach has got a right to claim the damages. So whether it would militate, and then the other question that would fall for interpretation is whether the right to claim a damage under Section 73 is something which is part of the public policy, and whether a party to a contract can waive a right to which a certain public policy element is attached. So these are the questions to which we will try to find answers. Now, our contract law in India obviously owes its genesis to the development of law of contract in England. So let me quickly trace the English history on the issue. The contract is as old as the humanity knew about trade and commerce. So therefore, we will go back a couple of thousand years into humanity. And ever since there has been trade and commerce in humanity, there have been contracts entered into, and the world has never been a level playing field. In a contract, there are two parties, and one party can always have a stronger bargaining power. And the party who had the stronger bargaining power has always used the bargaining power to stipulate certain terms in the contract to his own advantage. Going back to the English history, until about the medieval period, that is up to the 17th, 18th century, the concept of just price and condemnation of usury was primarily based on the concept of the Aristotelian concept of justice and the Roman law of latio enormis. Both of this would broadly mean that whenever one party to a contract is subjected to an onerous term, then there has to be some equity made to ensure that he does not sustain any injury. The chancery courts in England, which were administering the common law, whenever they came across a particular transaction in which there was unfairness in a term in a contract, they would be guided by these principles of the Aristotelian concept of justice and the Roman law of latio enormis. And then came the Industrial Revolution and the 19th century. With it, it brought in a movement towards the economic individualism, the capitalism. And this particular period was dominated by the autonomy to contract. And largely the courts were guided by the Latin term of pacta sunt servanda, which literally means that the contract shall be kept. In other words, it would mean that if two parties have entered into certain terms and conditions, for them, that is the law. They would be governed by whatever they have agreed, regardless of whatever it is. Once they have agreed, they are bound by the terms. So there was a gradual shift, and then in the world of trade and commerce, so individuals started practicing the pacta sunt servanda concept, and there was emphasis on the freedom of the parties to make their own contract. And obviously, the parties who had greater bargaining power took advantage of that and stipulated terms which the English court called as unconscionable. Over a period of time, the English courts, which popularly applied the common law, felt that they cannot be mute spectators when they came across terms where there were unconscionable terms. So they felt that there was a need to protect the weaker parties from the effect of harsh terms of the contract. And this led to the launching pad for the development of the modern doctrine of unconscionability. One of the principles that was introduced in regard to these unconscionable contracts was the test of reasonableness. And this was first introduced by none other than Lord Denning in the case of Gillespie Brothers in 1973. So in the Gillespie Brothers case, what fell for interpretation was there was an indemnity clause. And under that indemnity clause, the indemnifier, who had the stronger bargaining power, obviously, had stipulated that he shall not be liable for any damages which is arising even out of his own negligence. And this was something which the court found that it was unconscionable. And Lord Denning ruled, and he laid down the principle that an exemption or a limitation clause should not be given effect to if it was unreasonable. So for the first time, this concept of this test of reasonableness was introduced in the English courts. Lord Denning also recognized the principle of inequality in bargaining. It was not only recognized, but it was introduced in this case. So the Lord Denning held that in the event that the court come across a case where there is inequality in bargaining, the vigilance of common law will watch over to see that the party with the stronger bargaining power will not abuse his power. This principle was noted by the Law Commission in the UK and in its recommendations in 1975. The Law Commission recommended that the Parliament make a law which states that a term which exempts the stronger party from his common liability should not be given effect to except when it is found to be reasonable. So that eventually led to the enactment of the Unlawful Contract Terms Act 1977. So in England, there is a statutory law which deals with unlawful contract terms. The situation in India, I'll come a little later. The common law jurisprudence which developed in England until this unlawful contract terms was enacted eventually culminated in the statutory recognition of principles that was fundamentally built on the foundation of inequality in bargaining. In other words, the jurisprudence that was built was on the basis of cases where a stronger party had taken undue advantage of his position in imposing certain onerous conditions in the contract. So the question that arose then was, would those principles of inequality in bargaining apply in respect of commercial contracts between businessmen and business entities where the parties were having equal bargaining power? That was answered by the House of Lords in the 1980 judgment in the case of photo production versus Securicor Transports. In the photo production case, the House of Lords upheld an exemption clause which insulated one of the parties from incurring any liability. The House of Lords felt that the test of reasonableness can be applied only when there is, it felt that even the Parliament did not apply the test of reasonableness where the parties were of equal bargaining power. As a matter of fact, the House of Lords proceeded to rule that a contract between parties where both of them are well enough to take care of their own interests, where parties are aware of the risks involved, then in such a situation, what matters is what the parties have agreed. And then the sole duty of the court is to construe the contract in terms of what they have agreed. So therefore, there was a slight departure in applying the principles of inequality in bargaining. That the moment the court came to the conclusion that there is a contract where parties were of reasonably equal bargaining power, then the test of reasonableness would not be applied. In England and also in the USA, there have been statutory recognition of the fact that there can be unreasonableness and unfairness in the terms of the contract wherever parties do not have equal bargaining power. And even in countries like Germany and France, there are laws which render a contract void where one party exploits either the distressed situation or the inexperience or the weakness of the other party in order to obtain certain pecuniary advantages which are disproportionate to the performance which is given in return. So therefore, the English jurisprudence of reasonableness is something which can be applied where a person enters into a contract without perhaps independent advice and upon terms which are unfair, and when his bargaining is impaired by the reason of his either ignorance or infirmity, or which is coupled with the elements of either undue influence or pressures. So eventually the English courts recognized two types of unfairness in contracts. Firstly, the substantive unfairness where one of the terms of the contract were unfair. And the second one is procedural unfairness where either the consent was obtained with undue influence or during duress. So during the last century, there has been domination of the common law doctrine of inequality in the bargaining. But in the modern times, even the English courts appear to have shifted from using the doctrine of inequality in bargaining to the application of the statutory protection. Now they have the UCTA, which grants certain protections to, particularly in the domain of consumer contracts. So therefore, the concept of application of the doctrine of inequality has faded over a period of time. Now, coming back to the Indian position, obviously there is no statutory recognition of the principle of the concept of inequality in bargaining power or of the unreasonableness or unfairness of the terms of contract. However, the power of the court to deal with the so-called unconscionable terms are found in section 23 of the contract. Now, what does section 23 of the contract say? Section 23 says that where the consideration or object are either forbidden by any law, or if permitted would defeat the provisions of any law, or if the court regards such objects or consideration as immoral or opposed to public policy, then such consideration or object would be unlawful. And if the object or consideration is unlawful, the contract would be void. So therefore, the Indian situation is slightly different. So the emphasis here, I mean, to find out whether it is opposed to law may be much more easier. But the court has got the power to rule that if a particular term is opposed to public policy. Now, if it is opposed to law, it is much more easier. For instance, if I have to give an example, if there is a contract between a buyer and seller, and there is clear law that when the sale takes place, a certain amount of tax has to be deducted, and both this buyer and seller agree that they are not going to deduct any tax as required in law, straight away it is in violation of that particular law, and then the court can rule that it is, if permitted, it would defeat the object of law. But then the public policy element having been recognized in section 23, the definition of public policy is not found in the Indian Contract Act. It first fell for interpretation by the Supreme Court in the landmark case of Central Inland Water Transport Corporation versus Brojonath Ganguly. I mean, all lawyers, as the students of law in their colleges, would have come across this particular case. So this particular case pertained to a case of an unfair term in an employment contract by the appellant Central India and Water Transportation, it was a instrumentality of the state. The Supreme Court said that the public policy connotes some matter which concerns the public good or public interest. Now, the concept of what is good or what is harmful to the public good or public interest is something which has been changing from time to time. Now, in this particular judgment, the Supreme Court eminently captures the variance in what is public law in the English jurisprudence right from 1902 until the modern times. They begin with the opinion rendered by Lord Davey in 1902 judgment, where he said that public policy is always an unsafe and a treacherous ground for the legal decision. Later in 1980, Justice Barrow opined that public policy is an unruly horse, and once you get astride, you never know where it will carry you. And then Supreme Court notes that Lord Denning was not a man who would shy away from unmanageable horses. And he said, Lord Denning, in the case of Enderby Football Club, he notes that with a good man in the straddle, even the unruly horse can be kept in control and it can jump over obstacles. That is what Lord Denning says. So therefore, public policy, if handled appropriately, is something which can be molded to grant justice. So that finally brings us to the question of whether exclusion of contracts would offend the public policy in India. Now, in the modern times, we come across various contracts where there is limitation of liability. If you go to a particular launderer and if you give your clothes for laundry, without you knowing, the moment you hand it over to him, he gives you a bill. There is a contract entered into in which there would be in fine print a limitation of liability. He would have said that his maximum liability would be the amount that you would have been liable to pay to him for his services. And it will not be equivalent to the value of the garment which you would have given for the laundry. Similarly, this applies in courier case in respect of courier. And the courts have upheld the validity of such limitation of clauses, limitation of liability clauses. But what about a complete exclusion? Can there be a contract where parties can agree that no damages would be payable whatsoever under whatsoever circumstances? Now, these kind of clauses as whatsoever may not be there. But in the domain of infrastructure contracts, one will come across these kind of clauses where there is exclusion of damages. So let us take the case of a typical infrastructure project like construction of a large building or construction of roads or bridges or viaducts. There are two parties to the contract. One is the employer and the other is the contractor. The employer wants the project, the infrastructure project to be completed, and therefore he calls for a tender. There is a standard set of rules which typically is called as the general conditions of contract, in which the entire conditions of contract are laid down. Of course, a copy is supplied to the contractor, and the contractor is someone who is vying to get that project. It is not just one. When the tender is called, there are several of them who are going to bid. There is sufficient time for them to go through the document, seek legal advice. They go through the terms and conditions, and typically there is a pre-bid meeting in which the terms of the contract are discussed. And in these kind of contracts, the employers normally stipulate a condition that if there is a delay in handing over the site for the purpose of construction, or in handing over certain drawings according to which the contractor has to execute the contract, or in issuing any instructions, they will try to insulate themselves. This is typically done because of in handing over site, there can be various factors involved. There can be issues of land acquisition. There can be certain encumbrances on the land. So, sometimes it is not known what is the exact time that is taken to clear those encumbrances, or if there is a stay of any court in acquisition of that land, how long that stay would operate, this is not known. So in order to insulate themselves, the employers stipulate certain conditions. Now, if we can have a look at, so what I propose to do is, first let us have a look at a typical clause in a standard infrastructure project as to what kind of exclusion of the liability would be imposed.
Exemption clause.
The exemption clause, yes. It is the exemption clause. So here is a typical exemption clause in an infrastructure project. So it would read like this. In the event of delay by the employer to hand over to the contractor possession of land necessary for execution of work, or to provide necessary drawing or instructions, or to do any act or thing which has the effect of delaying the execution of the work, then, notwithstanding anything contained in the contract, it shall not alter the character thereof, or, this is very critical, entitle the contractor to any damages or compensation thereof, but in all such cases the employer may grant such extension of completion date as may be deemed fair and reasonable. Yeah. So you can close the stop sharing this. So therefore, what are the different ingredients here? Typically the employer is saying that in the event that there is any delay in handing over the land or drawing, I will give you more time to complete the project, but I am not going to pay you any compensation. Now, these conditions are stipulated well in advance, and it is made known to the contractor. There can be negotiation. The contractor may ask for waiver of that, and the employer either may or agree. In my experience, the employers never agree on that. So, with these kind of clauses, let us now examine what is the development of law. The very first case in respect of these kind of clauses fell for interpretation of the Supreme Court in India in 1988. The first judgment was in the case of Continental Construction Company versus State of Madhya Pradesh. In this case, there was no complete exemption. There were two clauses which was stipulated in the contract in this case. The first clause said that if at all you have a claim for compensation, you have to make it within 1 month. So there was a time stipulation. And the second condition said that you shall complete the contract within a stipulated period, let us say 1 year, and this is the X is the price of the materials and Y is the cost of the labor. And even if the contract period goes beyond the stipulated period, the price of the material and the labor charges will remain the same. But in this contract, the contract period went beyond what was agreed, and the contractor asked for higher price. He said there was a increase in the price of materials and the labor charges. He asked for higher price, and he also had a claim which he did not submit within a period of 1 month. Eventually, the matter went before Supreme Court, and Supreme Court said that when the contract stipulated that there shall not be any increase in the price of the materials or in the labor charges, and when it also stipulated any claim ought to have been made within 1 month, and when it was not made, then the Supreme Court said no such claim can be entertained. So the Supreme Court gave importance to the terms of the contract. Although the terms of the contract may have been onerous, the Supreme Court ruled that the terms of contract will outweigh the other considerations. Later, about a year later, an interesting case came up before the High Court of Andhra Pradesh in the case of State of AP versus Associated Engineering Enterprises. The citation would be AAR 1990 AP 294. In this case, there was a civil contract which was awarded by the state government to the Associated Engineering Enterprises. And this contract was governed by the Andhra Pradesh detailed standard specification. And clause 59 stipulated the condition like the standard clause which I read to all of you some time back. And that standard clause said, no damages shall be payable under whatsoever circumstances if there is delay on the part of the government in handing over site or drawings or whatever. And there was a claim made by the contractor, and matter went to arbitration, and the arbitrator granted certain claim. And the High Court of Andhra Pradesh ruled that the award has been passed by ignoring the express terms and conditions in the contract, and it said the award is not sustainable in law, and it set aside the award. That judgment of the High Court was carried in SLP to Supreme Court, and Supreme Court found no time. By 1991, the Supreme Court ruled, upheld the order of the High Court, and said that that when there is a specific bar in the contract, no compensation could have been paid. So once again, it gave primacy to the terms of the contract. In 1994, yet another case came up from Andhra Pradesh, where the same clause number 59 of the Andhra Pradesh Detailed Standard Specification clause was applied. And once again, the Supreme Court said that where the contract plainly barred the appellant from making any claim, then it was not permissible to make a claim. And then if the arbitrator awarded in spite of such a claim, then the Supreme Court said the court is entitled to intervene and set aside that particular award. About 5 years later, in 99, the case of Steel Authority of India versus J.C. Buddharaja, the citation would be 1999 8 SCC 122. In that, there was a similar clause, and the arbitrator had granted certain claims. And the Supreme Court said that the arbitrator may have had the jurisdiction to entertain a claim, but it said that he did not have the jurisdiction to render an award when there is a specific prohibition in the contract. And it went on to hold that when there is a specific prohibition, in spite of that, if the arbitrator awards a claim, it constitutes a jurisdictional error. So therefore, the Supreme Court, which was earlier holding that the arbitrator has to strictly follow the terms of the contract, now went ahead and said, if the arbitrator grants any claim in spite of a specific bar, then it constitutes a jurisdictional error. Then in the same year, yet another case called Rajasthan State Mines and Minerals Limited versus Eastern Engineering Enterprises, and the citation would be 1999 9 SCC 283. Also fell for interpretation by the Supreme Court. In this case, also where there was a specific bar and the arbitrator had awarded, the Supreme Court said that if the arbitrator awards, entertains and awards any claim in spite of there being a specific bar in the contract which the parties have agreed, the Supreme Court went ahead and said it will constitute misconduct on the part of the arbitrator. So there was further expansion of that particular clause. And then 3 years later, in 2002, a very interesting case came up before the Supreme Court, which gave a new dimension to the concept of the exclusion clause. That's the case where, for the first time, the Supreme Court tried to carve out certain exceptions to this jurisprudence which had developed right from the Continental Engineering case up to Rajasthan Minerals. In the General Manager Northern Railway versus Sarvesh Chopra, the citation would be 2002-4 SCC 45. There, the railways had given some contract to Sarvesh Chopra of drilling some bores. And then obviously there were some disputes and matter went into arbitration. And there was a clause which stipulated that no claims shall be entertainable if in the event of delay by the railways. There was delay by the railways and in spite of that, the arbitrator entertained, and then he gave certain amount as a compensation for the delay. The matter was carried in appeal, and finally the matter reached the Supreme Court. The Supreme Court followed the decisions in the case of Associated Engineering Company as well as of the High Court of Andhra Pradesh High Court, and also of the Ramalinga Reddy, affirmed both of them. It affirmed the ratio and said that we are following this, but then proceeded to carve out certain exemptions by placing reliance on Section 55 of the Contract Act. Now, what does Section 55 say? 55 identifies 3 circumstances. Now, 55 falls under that chapter which deals with the chapter 4, if I'm right, which deals with the reciprocal promises. And 55 identifies 3 circumstances. The first circumstances would say that the effect of where one party is required to perform his obligations within a certain time and he does not do so, then the other party has got a right to declare that the contract is become voidable. The second part deals with where time is not the essence of the contract, and if there is a violation of the obligation to perform, he can seek the damages. The third part, which was applied by the Supreme Court, deals with a situation where time is the essence of the contract, but where the one party, the promisor, does not perform within a particular time, and the promisee is willing for an extended time to grant more time for the performance, then the law says Section 55 says, if the promisee consents for an extension of time, then he cannot claim any compensation except in the event when he puts the promisor on notice that he is going to claim compensation. But what is not forthcoming in Section 55 is, let us apply the principles of Section 55 to a case of, okay, no, this may not be necessary. This may not be necessary. You can take. Let us apply the principles of Section 55 to an infrastructure project. Let us say there is delay by the employer to hand over certain portions of the site, and then there is some extension of time, and the contract is completed. After the contract is completed, in spite of there being a bar, the contractor claims that because of the delay, I have suffered certain losses. And at the time of seeking extension of time, the contractor would have put the employer on notice that you can grant me more time, but I am going to claim compensation from you, although there is a bar against claiming compensation. When the employer receives this notice, the employer replies and very emphatically states, look here, I am not going to pay you any compensation. Our contract says no compensation is payable, so our contract conditions will remain. So this is something which is not captured under Section 55. Section 55 simply says that if the contractor puts the employer on notice, that is, promisee puts the employer on notice, then he can claim compensation. Section 55 is silent on the situation where the employer bounces back a reply and says, your terms are not acceptable to me. Now, what Supreme Court did in the Northern Railways versus Sarvesh Chopra cases, it applied the provisions of Section 55 and noticed that the contractor had put the employer on notice. He had, at the time of giving additional time, the contractor had said, you grant me more time, but I am going to claim my compensation. And the facts as discussed in the Sarvesh Chopra case is silent as to what was the reply of the employer. Did the employers reject the new terms which are put by the contractor? It is not known in the judgment. So therefore, to that extent, I would say the stipulation in the case of Northern Railways versus Sarvesh Chopra would be applicable only where the contractor stipulated this new term that he is going to claim compensation, although the contract stipulated that no compensation can be applied, only where the employer doesn't reply back saying that he has not accepted the new terms and conditions. Nevertheless, Sarvesh Chopra followed Ramalinga Reddy and Associated Engineering and eventually carved out this exception. Now, there is an interesting interpretation of Sarvesh Chopra judgment by the Delhi High Court in 2014, so I'll come to it a little later. But in 2003, another interesting case came before the Andhra Pradesh High Court, where for the first time the public policy issue came. In that Andhra Pradesh judgment, in the case of T.H. Chowdhury versus State of Andhra Pradesh, 2003 SEC Online AP 494. In this case, that same clause number 59 of the Andhra Pradesh detailed standard specification, which barred claim of compensation, fell for interpretation. And a very interesting judgment rendered by Justice Bhikshapati, where he says that he refers to Section 29 and says, under Section 29, any term of a contract which, if permitted, would defeat the provisions of law, or if it is opposed to public policy, can be declared as void. And he said a contractual term where a person is barred from claiming compensation will straight away run into the teeth of Section 73. He said 73 gives an exclusive right, an emphatic right to a contractor who has suffered a breach of contract to claim compensation. Now, can you bar that? He says no. Then he also takes up the issue of the waiver of rights. He says, can it be treated that the contractor has waived his right to claim damages? Then he goes on to say that parties have the jurisprudence that developed this far shows that the parties can waive any rights that they have contractually or in statute. But he says that the parties cannot waive any right which has got a public policy element. And he says this waiver of a right to approach a court when there is a breach of contract and claim compensation has got a public policy element by linking it to section 73, and he says any term in a contract where there is a complete bar in claiming any compensation, he says runs into the teeth of section 23, and he went on to declare that section 23, that particular stipulation of the term in clause 59 of the Andhra Pradesh detailed standard specification is void. Now, unfortunately, that matter was not carried in appeal to Supreme Court. Otherwise, we would have had a clear declaration in law. So we do not have that declaration in law. So anyway, that was for the first time when a High Court declared that a stipulation which restrict the claim of compensation runs into the teeth of section 23 and it is void. Regardless of this, in 2006, one more matter came up before the Supreme Court in the case of Ramnath International Construction versus Union of India, 2007 2 SCC 453. In this, the Supreme Court followed the earlier judgments and ruled that if there is a contract which bars claim of compensation, the arbitrator is bound by it. That was also followed in 2008 in the decision of Union of India versus Chandalwada Gopal Krishna Murthy, 2010 14 SCC 633. Then came in 2003 an interesting judgment came in the case of Asian Tex versus Union of India, and the citation would be 2009 10 SCC 354. In this case, there was a similar exclusion clause, and in the party, the contractor in this claim that if there is an exclusion clause, it will bind only the employer, that is the party, and he contended that it will not bind the tribunal, the arbitral tribunal. And for this, the contractor relied on two judgments of the Supreme Court. One is in the case of Port of Calcutta, where the stipulation was that the employer shall not entertain a claim for interest. And there the Supreme Court said the bar is only against the employer in claiming interest, but the arbitrator can grant interest. And then the second case that was relied upon was the Bharati drilling case, where no law was laid down by the Supreme Court. The Supreme Court only referred to the arguments made in the Port of Calcutta case. But yet, in Asian Tex case, the Supreme Court went on to rule that if there is a bar in a stipulation of restriction or exclusion of the compensation, the Supreme Court went on to say that it will bind only the parties to the contract, it will not bind the arbitral tribunal. That this judgment, in my respectful opinion, is something which requires revisitation, because this was rendered by following Bharati drilling, which did not lay down the ratio, and in the Port of Calcutta, it was only in relation to grant of interest prior to reference of the dispute to the arbitration. So therefore, Asian Tech judgment is something which probably we can discuss in some other webinar as to why Asian Tech requires revisitation. But nevertheless, as of today, it holds the field. Asian Tech went ahead and said that a bar against claim for compensation binds only the parties and not the arbitral tribunal. And after this came the very famous case before the Delhi High Court in the case of Simplex Concrete Piles India Limited versus Union of India, 2010 SCC online, Delhi 821. In this case, typically there was a contract between Union of India and Simplex Concrete Piles in respect of executing some civil works. And there was this bar against claiming any compensation in the event that there was a delay. Now, when this came up before the Delhi High Court, a brilliant judgment rendered by Justice Valmiki Mehta, when he rendered this judgment, he had two judgments before him. One of Ramnath International, which very emphatically stated by referring to the earlier judgments that the arbitrator is bound by the terms of the contract and he has to operate within the four corners of the contract and he has to follow the terms of the contract. On the other hand, he had the Asian Tech judgment, which said that the arbitrator is not bound by it. So with trepidation, he says, he deals with which judgment to follow. And then after referring to a catena of judgments on when a high court is facing the situation of which judgment to follow when there are two conflicting judgments, and he says the law is that the High Court should follow that judgment which it feels has laid down the correct law. And eventually, he goes on to say that the Asian Tech lays down the correct law, and he does not specifically refer to the judgment of Justice Bhikshapati, but he independently renders that section 23 will fall for interpretation, and the stipulation of the contract which bars the claim of compensation, he says straight away runs into the teeth of section 23, and the Delhi High Court renders that that particular clause is void. And anyway, that I'm given to understand that the simplex judgment is challenged before the Supreme Court, and it is pending consideration before the Supreme Court. As of now, the Delhi High Court judgment remains as a judgment of the High Court, which obviously is in conflict with the judgments of the Supreme Court. But anyway, about 8 months after the judgment of simplex was rendered by the Delhi High Court, then came the last of the judgments on this particular field by the Supreme Court in the case of ONGC versus Wig Brothers, a judgment rendered in 2010, and the citation would be 2010 13 SCC 377. Now, in ONGC versus Wig Brothers, a judgment rendered by Justice R.V. Ravindran, very emphatically by referring to the previous judgments, the Supreme Court went on to hold that the terms of the conditions, terms of the contract are supreme, that the parties are bound by it. If there is a clause which bars claim for compensation, so be it. The claim shall remain barred, and the arbitrator cannot grant. And if he grants, that will be a jurisdictional error. You may recollect that I showed a sample agreement, sample clause, and that clause was picked up from the judgment in the case of ONGC versus Wig Brothers. So as of now, the field is held by the judgment in the case of ONGC case, where until today, the supremacy of the terms of the contract will continue. But the fact of the matter is that in no case the Supreme Court has considered, or rather tested, either the reasonableness of a contract which completely bars the claim for compensation. The Supreme Court has also not tested this from the angle of public policy. The Supreme Court has also not tested whether such a contract would go into the teeth of section 23, or whether it would defeat the provisions of section 73. So to that extent, this area remains a gray area. Eventually, on the development of law, I would like to conclude by referring to a judgment of the Delhi High Court in the case of Public Works Department versus Navayuga Engineering Company Limited. The citation would be 2014 SCC Online Delhi 1343. In this case, there was a contract between the Public Works Department of Delhi and Navayuga in respect of execution of some civil works. And here, the example that I gave in respect of section 55 of the Contract Act was interpreted. What happened was the contract included a specific bar against claiming compensation if there was a delay. There was delay in execution, in handing over certain portions of the land by the PWD department. And later, Navayuga made an application for extension of the time. The extension was granted. But while seeking extension, Navayuga exercised its rights under section 55 of the Contract Act and said, I am going to seek compensation later. I'm reserving my right to seek compensation because I have already suffered loss because of your delay in handing over the site. The moment such a letter was received, the PWD department wrote back and said, you may claim compensation, but your term is not acceptable to us. We are bound by the terms of the contract. Now, in spite of such a reply by PWD department, Navayuga accepted the extension of the contract and went ahead and completed the contract. And therefore, the Delhi High Court says it refused to follow the judgment in the case of Simplex. And the Delhi High Court said that these kind of contracts are valid in law. And it also distinguished the judgment in the case of Sarvesh Chopra, and it said in Sarvesh Chopra, as I said earlier, we do not know whether a reply was given by the employer when the contractor said, I am reserving my liberty to claim compensation in terms of section 55. But here, the facts very clearly pointed out that the employer PWD very clearly said there is no change in the terms of the contract. So the Delhi High Court said when the employer had specifically said that there would not be any change in the terms of the contract, the contractor cannot be given benefit of section 55, and it said that the terms of the contract will prevail, and then it said that no compensation is payable. So friends, so therefore this is the development of law on this particular field, and therefore there are a few questions which, as I mentioned earlier, which still remain unanswered. But a couple of pointers that I would like to give is whether in these kind of cases can the contractor contend that there was no equal bargaining power. Obviously that is not permissible, because right from the judgment in the case of the House of Lords in the photo case, which was followed by the Supreme Court in the Central Inland Water Transportation case, there also Supreme Court noted that where parties are of equal bargaining power then in commercial contract, then the test of reasonableness will not be applied. And in the SKJN case and ICOM case, the Supreme Court has held that in the modern times, mega corporations which take up contracts with state entities, they have large money at their disposal and they're aware of the risk, and they cannot contend that we did not have equal bargaining power. So therefore, that argument is something which is not available to a contractor. So therefore, the only narrow compass that would remain for interpretation is that if there is a complete bar against claim for compensation, and should the Supreme Court carve out any exceptions, in my personal opinion, a couple of exceptions may have to be carved out. Number one, what if there is gross negligence on the part of the employer, and that negligence is very apparent on the face of the record? What if there is negligence which is deliberate? Under those circumstances also, can the court remain silent and not grant any compensation? So therefore, some exceptions may have to be drawn. And then before I conclude, I would refer to one more principle which has been applied by the courts in England, and which probably can be applied here as well, is that the test is whether the terms of the contract are reasonable when it was entered into, not at the time when there is a breach, and not having regard to the seriousness of the consequences of the breach. At the time of entering into the contract, did it look reasonable? If it is reasonable, then it should pass muster. So that is something which probably we do not have an authoritative judgment by the Supreme Court. And I think we all should hope and look forward to a judgment of the Supreme Court which is authoritative and clears all these issues. So thanks Beyond Law, thanks Vikas for giving this opportunity to share some of my thoughts. And if anybody has any questions, I would be very happy to answer.
Yeah. One of the fascinating facts of the webinar was that the participant continued to remain stagnant. And they say that it is only on the ECG lines, etc. Once they are flat, it gives a threat perception. But in a webinar, if the participants remain continuous, it shows that actually one has been engaged totally in the insightful session.
Thank you.
Meanwhile, two questions have come. Ritika Javri, does the arbitral tribunal have the power to pass an award for idling charges due to stay order beyond the scope for the contract?
Yes, as per the current prevailing jurisprudence, the arbitral tribunal definitely has the power. But what you have to see is the terms of the contract. Does the contract bar any such claim? If there is a bar, as per the prevailing law, the arbitral tribunal does not have the jurisdiction, unless you go ahead and question the validity of the term. But to answer your question, without there being a stipulation of bar against compensation, arbitral tribunal definitely has got the power to consider that claim.
This is by S.S. Shinde. No, by Sonita, after expiry date of agreement, shall we go to the arbitral tribunal? After the expiry date of agreement.
See, after the expiry, you have to essentially see the terms of the contract. Does the contract provide any term for extending the term of the contract? If the term can be extended, under what conditions? The typical clause which I read to you indicates that if you seek extension of time, then you are forfeiting your right to seek compensation. But without seeking time, if there is any delay, if you terminate the contract then and there, obviously the full power under section 55 and 73 of the Contract Act is available to you, and you can claim compensation to the extent you have proof to show that you have suffered losses.
This is S.S. Shinde. Many times it is seen that appointed arbitrator passes an award won against the terms of the contract and without following due procedure. Whether the appointed arbitrator can be held accountable and can he be sued or prosecuted thereafter?
No. It's like if a court passes a wrong order, which
protection under the good faith.
You cannot sue the court. So similarly, you may challenge the award on the ground that it is in conflict with the public policy of India. If you can demonstrate that the award is in conflict with the public policy of India. Now, what is public policy of India is too clear. You can read the associate builder's case. That will will clarify to you. But you cannot sue the arbitrator. You can challenge the award.
Because they say that it is only a thought process of that particular judge.
Yes.
Which has been given a judgment, and that is why the remedies of appeal and revision, etc. lie.
True.
This is by Swati Kapadia. Delayed due to pandemic. Suspension of contract period for 6 months. Can damages be claimed? Contract says no damages.
If the contract says no damages, if contract says no damages payable.
Yeah.
And what is the first sentence?
On account of pandemic, the suspension of contract has taken place for 6 months.
This on account of pandemic, if the other party is able to demonstrate that it is a reasonable term, then you may not be able to claim damages. So it will essentially boil down to the reasonableness of that term. Now, if during the pandemic, if the other party was unable to perform its obligations, then obviously you cannot claim compensation for that. If you are able to demonstrate that the pandemic did not come in the way of the performance of the contract by the other side, then you will have to, if there is a specific term which bars claim of damages, you may be governed by the arbitral clause. But there is one thing which I must point out, which I did not. Now, all the case law which I discussed is all in the domain of arbitration. Including up to ONGC, the Supreme Court says the arbitral tribunal is bound by it. So one question that would remain is whether what if it is a court? If an infrastructure dispute, typically now every infrastructure dispute, inevitably there would be an arbitration clause. No, let us assume that there were not to be an arbitration clause and it were to be before a court. There is no case law on that. So to that extent, it has remained res integra. So it is time that the Supreme Court renders a judgment and clears the air in this respect.
Like we had discussed on the arbitration, in a normal writ petition, we always challenge that the clause is bad in view of section 23, relying upon basic judgment of Brojanath. But since the arbitral tribunal has to adjudicate in terms of the Contract Act, do you believe that the contractor or anyone who feels aggrieved, he will first have to take the first step to file a petition, etc., stating therein that this clause should be held to be bad, or whether the arbitrator itself can decide?
The arbitrator himself can decide. In my opinion, the arbitrator can also declare that it is opposed to public policy. See, the expression in section 23 is where a court regards it as immoral or opposed to public policy. Now, what is the arbitral tribunal? The arbitral tribunal is only an alternative method for dispensation of justice. What a court is capable of doing, the arbitral tribunal is capable of doing. So if a court can rule a particular term as opposed to public policy, why can't the arbitral tribunal do? So therefore, to that extent, I don't think we can say that the arbitral tribunal, being a creature of the contract, cannot rule on the validity of a contract. It can. In my opinion, the arbitral tribunal can entertain a challenge to a particular term and declare that it is opposed to the public policy.
So according to you, there should be, but there has to be a prayer to that effect.
Yes, there has to be a prayer. Yeah, that is the point which I want to make. You are right, Vikas. Unless there is a prayer, you cannot. So therefore, in the same suit or in the same petition, your first prayer must be to declare that particular provision is void in terms of section 23. And then you claim other consequential relief, as though that term never existed.
This is Rohit Mansukani says, does that mean even an illegal ultra vires clause shall be binding in case of an arbitration?
Because your question we already pre-answered.
Yes, yeah.
If it is illegal, you can always question it. You can question the correctness.
But another challenge would be sometimes it says like the subtle difference between the court and the tribunal as to whether once it is a tribunal, you will allow the tribunal to declare it. Only I feel that gray area would be wherein it says that it is against a public policy. Yeah. May not declare it to be ultra vires, but it can be said that it is against the public policy. Therefore, this clause would not be having a binding effect.
Yes. No, in 23, even if there is an expression which says, if permitted, it would defeat the provisions of law.
Yeah.
So therefore, if there is a particular term in the contract, which if permitted, and Justice Bhikshapati used that in the T.H. Chaudhary judgment. He said, if permitted, this would defeat the provisions of section 73 is what he said.
Grish Goda, limitation to seek additional claim is construed from the date of completion of work or from the date of final payment. It's a tender work.
Sorry, limitation is?
Limitation to seek additional claim is construed from the date of completion of work or from the date of final payment of tender work.
The limitation essentially will boil down from the date of the cause of action. And if it is an arbitration, it would be from the date your notice of reference of the dispute to arbitration is received by the respondent. That is when the limitation clock is set in motion.
In terms of sections of this thing, from the date of acknowledgement or when the cause of action actually arises. Because sometimes with the acknowledgement also the limitation starts, yes, until unless we show it's a continuous cause of action.
Yes.
I think we don't have any other question. Yeah, I will just check it on the Facebook. No. So thank you friends for participating in the webinar, and we are quite happy to seeing that it was a weekend and still the participants actually logged in not only on the platform of the Facebook, YouTube, or BeyondLawCLC, as well as on this platform. And tomorrow's webinar is on medical negligence under Consumer Protection Act. It is by Justice Paramjit Dhaliwal, a former judge of Punjab Haryana High Court, and presently he's the president of Punjab State Consumer Redressal Forum. So do stay connected at 5 p.m. And Mr. Kamath, it was a quite engaging session and it gave certain thoughts as to where we can proceed further. Because rightly, as you said, there are certain gray areas which actually requires to be looked into, and sometimes certain areas are such where it has been actually not been taken up. And once you get a right ignite in the thought process of mind, then it actually starts off where someone on this platform may take over forward in one of the petitions, and then it actually lays down the proper law in that effect so that it's not a gray area and we have a crystal thought process.
Absolutely.
Thank you once again to our Mr. Arvind Kamath and his son Angad Kamath, who helped us to connect with him. We are quite enamored the way he took the things forward, and the session, as he rightly said, and it is actually, I had also seen that this is one of the areas where we don't have much of the material, not only in writing, but as well as on the webinars and seminars. Thank you, everyone. Stay safe, stay blessed.